Good afternoon or good morning, everybody, depending on where you are on this planet. I've seen that there are people registered from China to California, so I'm looking forward to speaking and hearing the panelists today, but also at reading questions coming from around the world in the chat. Today is our second webinar related to the Vis Moot. We will talk today about life science and pharma industries and commercial and legal aspects. And last week we spoke about the joinder of parties. If you have missed that event last week, feel free to look at the recording that is on our website in the video gallery, and that is also available on YouTube. But today we're going to focus on the life science industry, and it's going to be much more commercial and experience-based, a little bit less legalistic, even though still it will be to a certain extent. And we have the fantastic luck today to have very bright and experienced lawyers who have all of them at some point at least worked in an industry pharma or in one of the actors of the pharma and life science industry. And we also have some of them who have moved to private practice and some of them who are still there and in some of the most famous companies of the world in the pharma industry. I am going to start the presentation now. You have seen already all our panelists of the day. And now I will start the slideshow. Sorry, I see it's not at the beginning yet. One of the joys. Almost there. That's just for those of you who don't remember why they are here. And now let's start. First of all, good morning and good afternoon. I'm Caroline Ling. I am the Executive Director and the General Counsel of the Swiss Chambers Arbitration Institution. I have not worked in the life industry, and hence I count on my panelists to teach me a lot of things today. And I will help as much as I can as a moderator. Today we will hear first Alexandra Carrel, who is going to walk us from fundamental research to the patients. And then we will hear Daniel Bletzler, who is the General Counsel at Lonza, and who is going to talk about the race against time, mutations, skill, complexity, and more. By the way, Daniel, why aren't we all already vaccinated? We will look about that. Then we will hear Martin Berchtold. Martin is working for a Novartis company called Advanced Accelerator Applications, and he's going to talk to us about the collaboration and the deals that the companies make together to access the markets. And at the end, of course, with every contract, every collaboration, there is a risk of dispute. Some of them turn into a real dispute and a claim, and we will hear Claudia Goetz-Sterlin, who is a partner now at Kellogg-Skahar and who used to work at Novartis. So we will now start with Alexandra Carrel. Alexandra Carrel is a founding partner of her boutique law firm specialized in innovation. Prior to that, she worked at Inserm Transfer. Inserm Transfer is the French National Institute of Health of France. She worked there as a general counsel and as a general secretary. She also worked in several law firms in London, Geneva, and Paris, and is admitted to the Paris and to the Geneva bar. On top of that, she's also a certified licensing professional. Her expertise in intellectual property and business law allows her to assist her clients from the protection of their innovations to the outsourcing of their technology, including through the development, registration, manufacture, production, and marketing of their products. So Alexandra, can you please explain to us who are the main actors of the research and development of drugs?
Sure, thank you, Caroline. So getting to a drug on the market that will cure disease like COVID-19 takes a lot of time and a lot of money. Mainly, you have, first of all, an invention that is discovered in a laboratory. And to get that invention to the market will take almost 10 years. Academic labs make a lot of fundamental research, and they will bring the project to what is called the initial proof of concept, or POC. And that will be the invention which will be covered by a patent. When the invention is covered by a patent, the academics don't have the money to bring that invention further, and they will most of the time out-license that invention to industrial partners. When the invention is a very early stage project, it will not go to the big pharmaceutical companies from that stage. It's too early and too risky for big groups, and the startups will take over. Very often, the startups will be created from the lab, and they will involve the scientist which has found the new molecule or the new drug. This stage is a very strategic stage and is covered by the licensing in agreements, which will be taken by the startup, and the startup will take over the project and bring it then as far as it can, raising money so that it is de-risked and the industrial partners can be interested in buying the project. The last actors, of course, are the groups, pharma groups. They will take over the project very often at the end of the phase 2 clinical trial and bring it to the market through the phase 3 and the commercialization. As you can see from the slide that Caroline is just showing, the amount of money that has to be invested is huge to get a product on the market.
Many thanks, Alexandra. That was really very interesting already. What type of contracts cover the relationships between the various actors of the drug development?
So there are many contracts in the life science industry. You will start with the academic contracts, which are most of the time academic consortium where only academics are parties. You can also have some of those contracts that are with industrial partners from the beginning, but it is usually when the project has already been patented through the academic research. Then you will have discussions with industrial partners that will be covered by what we call NDAs or CDAs, which are non-confidential agreement, non-disclosure agreement or confidential agreement. Then it is very often that you will have the license to the startup, which will be with a collaboration with the startup in order to further develop the process, the invention or the technology. At this stage, it is really working hand in hand, academics and startup. When the project is very early stage, the startup cannot take over by itself. It really needs the help from the academics and most of the time from the scientist who has invented or found the new technology that will come on board in the startup as CSO, that is Chief Scientific Officer, or as a member of the scientific board to help further development. Then when you get to a molecule that has shown effect, not only in cells, but also in animals, you will get to what is called the non-regulatory preclinical research, which is tests that you make with animals, and you will use a product that is still made in the lab of the startup. But that product cannot go to humans, of course. And that's where you have the service agreements, MSAs, they are usually called like that. And Daniel will expand on this. These contracts are signed with manufacturer that will help the scale up, that is, take your product that you have been making in your lab and bring it to an industrial quality and quantity. That's a real challenge. We have a lot of products that will not go through that path because you cannot scale up. That is, you cannot go from the 10 milliliter to the 8 or 10 liters that you need for a clinical trial because the product is not stable enough or because you cannot produce as much as you want. The yield is not good. And then, Caroline, if you go to the other slide. The next slide, thank you. Then you will continue the manufacturing. If your product, if you have gone through the GLP phase, you will go to what we call GMP phase, that is the quality needed for human testing, and you will start the clinical trials. There are several contracts that have to be signed, mainly with service providers and clinical trial centers. You have 3 phases in a clinical trial. Phase 1, phase 2, phase 3. As you can see from the slide, phase 1 is toxicity, phase 2 efficacy, and phase 3 is a huge phase where you confirm the toxicity and efficacy results. For certain disease, phase 1 and phase 2 can be made together, but most of the time the phase 1 is made with people who are not ill. They do not suffer from the disease. And then phase 2 will be tested on people who suffer from the disease with placebo. At this stage, when you bring a product to phase 2, when the startup has brought the product to phase 2, and it has shown efficacy, the pharma group will start being interested. And they will in-license the product, and the startup will out-license the product to the pharma, and the pharma industry will bring it to the end of the phase 3, and then the commercialization with the commercialized manufacturing, that is manufacturing in very big amount of products so that it can reach the market in sufficient quantities.
Many thanks, Alexandra. How does one choose to develop a new drug?
So there are a lot of factors. Some of them I have already mentioned shortly. I guess any scientist who finds a new molecule wants that molecule to get on the market, but then you have a lot of situations where the molecule cannot be developed. First of all, it can be for scientific reasons. What you have found in the lab, in the cells, cannot be reproduced with animals. And sometimes it can be reproduced with the mouse, but for the regulatory preclinical research, you have to test that on other animals, and you don't see the same effect on other animals, and then your product will not go further. Then other points that are important is also the market. If you find a new molecule for a disease that has already a lot of different drugs to help curing that disease or to help live with that disease, it will be much more difficult to bring it to the market. So usually you will push forward new medication or new drugs that answer an unmet need, either a situation where there is no drug or a situation where the drugs are not so efficient or do not cure the disease, but only help live with the disease. I have a very interesting example for that is I have worked on a project which never reached the market, which was HIV oral vaccine for women. And that was a fantastic project because it was very easy to take. It had a very good stability. It didn't need to be kept in very cold fridges. It was useful even at normal temperatures. So that was a very promising product. But that product was very costly to manufacture, and that project was abandoned because today the women who need HIV live in poor countries where there would be no money to buy that product. And so when you work in the life science business, there are a lot of products that you think are just fantastic, but will never reach the market. And not only for scientific reasons, but sometimes because of money. That's it.
Sorry, many thanks, Alexandra, for your presentation. I have a question from a participant who asked how you define innovation.
That's a very good question. So innovation for our firm is whatever is new and brings something to the people. So we work in life science innovation, but we also have digital innovation. You have technical innovations. You have medtech. You have digital health. All of that is innovation. So for the life science, which is the subject of today, an innovation is something that has not yet been invented, so which is new and patented. So I would think that an innovation is a new patent. It could also be know-how, but that's much more difficult to bring to the market in the life science industry. While for technologies, and also, of course, for digital and softwares, know-how is very strategic. So it really depends on the business and the activity you are referring to.
Many thanks, Alexandra. I will invite you now to have a look at the questions that are asked in the chat. And while we will hear now the next panelist, you can prepare yourself to answer those questions at the end if you find these are relevant and that you have a nice answer to give. We will now move to the next panelist. The next panelist is Daniel Bletzler. Daniel Bletzler is a General Counsel Corporate Transactions at Lonza. You may have heard of Lonza. It's one of the manufacturers of COVID-19 vaccines. For those in Switzerland, there is a very big factory in Valais that is very busy at the moment. Daniel Bletzler, as General Counsel Corporate Finance and Transactions at Lonza, supports Lonza in its M&A activities, such as, for example, the recent $4.7 billion divestiture of Lonza's specialty chemical business. And he also worked on some major transactions that have made the headlines recently. For example, the long-term manufacturing agreement that Lonza entered into last year with Moderna for the COVID-19 vaccine. We are very fortunate to have Daniel today on our panel. Daniel, as I said, there are various vaccines already approved. So why is it that we are not all of us already vaccinated?
Yeah, thank you everyone. Glad to be here. So I think that as Alexandra said, and one of the questions mentioned as well, I think it all starts with innovation. So in this COVID-19 situation, the first thing that needed to happen, and that did happen fortunately enough, is there was innovation. Someone started developing some vaccines. Actually, several people started developing vaccines. It was a race against time, and luckily enough, some of the vaccination processes are sort of relatively known and tested. So if you think, for example, about AstraZeneca vaccine, it's an incremental innovation based on technologies that are already known. There was also some bigger innovations, the mRNA, so that's the Pfizer vaccine, that's the Moderna vaccine. Those are technologies that were actually untested. So it's actually really amazing. I mean, they existed before. They have been tested in the sense that, there were more than 10 years of research, of intensive research behind it. But the actual use of any vaccine based on this technology did not exist. So there were some big bets that were made, and fast forward, technology that has been used. And I think these phases are very important. And I think Alexandra's chart were very good at explaining how the drugs progress through these various stages. And if you think back, who would have thought that you can fast forward so fast from finding the molecule, testing it with clinical trials, scaling it up, and then eventually manufacturing them. And now we are in this phase, looking back at the question, we are in this phase where we have the innovation, we have several drugs that have been that have appeared onto the market, that have been approved by various jurisdictions. So we have this phase, but we're still not vaccinated. And the reason for that is to be vaccinated, you need vaccine, and they need to be manufactured. And that's where the company I'm working for really interacts with this value chain. You need a very solid manufacturing process that allows you to have the vaccine available. And it's not just a matter of taking a few people together and asking them in a building to work on a workbench. What you need to have is, you need to have the capacity, you need to have the space. We are talking about, manufacturing of drug products. So drug products are very, no one wants any drug product to be manufactured with a lot of care and making sure that there are no contamination, that it is safe, and that you have a process that you can reproduce again and again and always have the same result. So you have quality requirements that are extremely high. So you need very skilled people. You need buildings that can manufacture those drugs. And often the bottleneck is equipment. You need the equipment. So when we started working on this with Moderna, the first issue we had was when can we get the equipment? We need to order it first so that it can arrive when it is manufactured, often abroad, often in China, often in other countries. So it needs to be manufactured, it needs to be installed, it needs to be tested, and only then can you start manufacturing after a proper technology transfer has occurred. So, to answer part of the question, or to answer the question is, the reason why we don't have a vaccine, all of us, or we are not all vaccinated, is because we are still in the process of manufacturing those vaccines. So that's one of the big challenges that the world will have in the next few months.
And what business model would work when there is so much uncertainty and pressure?
Yeah, so when we take back the situation back, last spring, when Moderna approached us and told us, whether we would be willing to be the exclusive external manufacturer for their product, we had a moral duty to work extremely fast. We had a moral duty to find business models that would work with this uncertainty of not knowing whether this drug will be successful. So if you think about it, back in March, this was an untested technology. No vaccine existed based on this technology at the time. Now we have two. We have Pfizer and we have Moderna that both use mRNA. But at the time, we didn't know, is it going to be successful? Is it going to be approved? Is it going to be safe? All these things we didn't know. And even if it's successful, is it going to be the most successful? Is there another one, another manufacturer, another drug that it will be better or cheaper or safer? So with all this uncertainty, we need to find something that is very flexible. And often lawyers are there as well to help, not only to draft what other people think is a good idea, but also to help them develop something that works. So for us, when it becomes complex and and risky, I think the best is often to find something that is very simple, that everyone can understand, that you can then go back when you draft, because of the simplicity, can be extremely scalable. So, to just give you a little bit of a hint of the model, which, there's nothing magic about it, that we developed. We developed a model where we rented out, if you want, a suite. So we rent out a room, which has everything you need for it, like steam, you need water, electricity, you need the facility itself, the equipment. So you rent that out and you get a fee for this. Then another factor that is important for scalability is people. So we rent out people, so we charge for the cost of the people. And then you have CapEx. So capital expenditures, so these are equipment. So who's going to pay for this CapEx, for example? So these are the type of questions you need to answer in the contract. And, who's going to take the risk of ordering, for millions of dollars worth of equipment when you don't know whether you're going to use it at all? So fortunately enough, beyond the pharma companies and the manufacturers, was a very big player as well in the world, which was governments. So a lot of the risk was taken, and I think we can be thankful for that. A lot of the risks has been taken by governments who were willing to step in and pay Moderna in this case for some of the investments they needed to make at risk, so without knowing whether any of this will be successful. So the US, for example, did provide more than $1 billion worth of funding to Moderna, which they spent partly with companies like us in the value chain to get the drug to market.
Yes, you must have been quite under pressure in the last 12 months, I guess. How else has the pandemic pressure tested our legal landscape and processes?
Yes, so maybe to go a little bit more on the legal side, if you want, that and many of the people on this call are very interested in arbitration and in litigation, and I'm sort of less working from this angle because I'm often more on the deal making, and whatever bad things I do end up with other colleagues afterwards. But when we thought about with the time pressure, the compressed time that we had to work on this, when it's a lot to do with very little time, we worked with legally relatively flexible tools such as term sheets. So we need first to put a framework that was going to set the way the two companies were going to work together. So it's a 10-year collaboration. So how are we going to work together for the next 10 years? But we didn't have time, and we didn't have well, we didn't have time to focus on all the details that you would have, that you would necessarily see on a long-term collaboration agreement in a matter of days. So that was just not possible, because it's not only the drafting, it's also the agreement phase. You need to agree on the details for everything, and that just takes time. So what we did is have the general framework where, at a high level, we managed to have an agreement, on the commercial terms I just mentioned before, but also then having some of the more detailed terms for the short run. So if you think about it, in this process, what was the most urgent? The most urgent was we needed to have equipment now, because that was a long lead item. We knew that from the time we order the equipment until we receive it, 4 months will go by, and then we need to install this equipment. So that's already 5-6 months. In a pandemic situation, you cannot afford to wait for the end of the clinical trials to start ordering the equipment. So you're going to have to spend tens of millions of dollars on equipment you don't know whether you need. And that was a very critical piece. So this part of the contract, this binding part, there was obviously a high focus on, the risk allocation for the ordering of the equipment. What would happen if it doesn't work? So luckily here, the business was the model was pretty easy, because, we shifted the risk back to Moderna, we shifted it back to the governments. So that was essentially the one area of focus, for example. The other one was we needed to hire people fast, and we needed to make some short-term investments immediately. And so what we knew is, if it's not successful, we need a ramp down. We need a time. We need to be paid, to undo what was done. And that also costs money. You have to pay people, for example, and you cannot just hire someone and then fire the person. So you have some commitments on the longer period. So for those pieces, we had to fix immediately within days. And then for the larger collaboration, for the manufacturing, how exactly, what exactly will happen if a batch fails or not? These pieces you can postpone a little bit in the discussion, and you can carry on in the discussion later on. And when the spirit is right, when the partner is right, when the environment is, we have a global pandemic, we have to get going, that's when things happen. I mean, I think you can do miracles in very short period of times with the right energy and the right focus.
Yeah, I guess that solidarity and good faith is key. And of course, there are problems all along, but when people are willing to solve the problems and to make it work, I think it should work at least. Many thanks, Daniel. You can look at the questions now in the chat, and we will come back to you at the very end. But we will now hear Martin. Martin is going to develop on collaboration, because I think that's key to what Daniel said. Collaboration is key, and also Alexandra, in order to develop a drug and to have it on the market and available for the users, or every one of us, actually, the complete population. Hopefully, collaboration is key. So we are going now to hear the next panelist, who is Martin Berstals. Martin is the head of legal at Advanced Accelerator Application, a Novartis company. It is also based in Switzerland, in Basel. Today we have a heavy weight in Basel, which is quite rare in our webinars, actually, but it's all for the best. Martin is a pragmatic and experienced business partner and manager with more than 10 years experience as a lawyer in private practice and also in-house at now Novartis. He holds degrees from the University of Basel and also Columbia School of Law in New York. In his spare time, He has lovely spare times. He enjoys running, marathons, karate, fine dining, and reading. So at least 2 of them he can still continue for the moment, and for the 2 others he may have to wait a little bit. But Martin, what are the reasons for entering into a collaboration agreement with a partner? I think we heard a little bit already from Daniel, but you may want to expand a little.
No, exactly. And I want to focus more a little bit on market access as well, right? So generally, and for the romantics amongst us, this might be like a surprise. We're not entering into collaborations like out of emotional reasons, but really for like various factors that might differ. So one of the key points when you look back in kind of the last 20 years, maybe, you will realize that often nowadays industry, in particular pharmaceutical companies, had gone a shift from having a very diverse portfolio to kind of more of a focused portfolio, kind of have top priorities, right? So partnering is like very important for a pharmaceutical company, in particular when you have still like a broad portfolio that you can basically maximize the launch and strategic brands that are defined as focus brands, and hence focus your internal time and resources on these priorities. And you can basically, depending on the type of collaboration you're entering in, you can better leverage that and focus actually more. Then a second point is you still have a big portfolio. Novartis, for instance, has that. I think we still have a very strong established brand portfolio where like old products at the end of the life cycle are in. So one point also to enter into a partnership there is basically to reallocate internal resources away from the established brands to again rather like focused or priority brands. Then one more important or further important point is that you can actually share the investment risks, right? You can manage your bottom line when you kind of partnering out. Another very important point is, and this is something that we have seen now in particular, and I think in the development of the vaccine, you can get access to a partner's expertise, to capabilities and resources, right? You have here BioNTech that has like this promising compound that they have been developing, but then you have like this giant Pfizer who can help actually kind of provide the facilities to be able to have a very broad manufacturing and resources amongst the world, the supply chain network that kind of BioNTech just for themselves would not have been able to get access to. So you have you can get access to a partner, some expertise to that extent. And then of course one important point is as it is like very expensive to develop products and do research and development, you can better leverage the cost of bringing a drug to the market, right? When you are entering into a partnership with another company or with a university. And there is a certain specific way of being able to do a risk mitigation that mostly applies for kind of markets where you might not have like access or kind of gained a lot of experience, where you might have an affiliate, where you're not like very certain about the political situation, the legal situation, the regulatory situation. There you can basically rely on a partner who actually has the know-how and knowledge how to best access this market. Another important point often is the pipeline gaps. You have like a pipeline and somehow at the end of the life cycle, you realize you don't have any kind of product that would be able to come out of your pipeline as a next product, but clearly you're making money out of having products in the market, and not just by developing them. Actually developing them costs a lot of money, right? So you can kind of search for business opportunities with smaller companies, for instance, with universities, to see where you find maybe a promising development program that might help you to close the gap for such a pipeline. And then overall, last but not least, it also is of course, if you look at all the points together, it is something that is driving, partnering is driving innovation. And I think, as mentioned before by Danielle and several times already, I think this entire COVID vaccine development shows how partnership around the globe can actually lead to some very innovative outcomes, and clearly to a more effective and efficient process to bring a product to the market.
Many thanks, Martin. What are the major legal or other considerations that you need to take in consideration before or during negotiation with a partner, and maybe even after the execution of the contract?
I mean, that's a very good, it's a very good point, a question actually. I think if you look at this deal-making process slide, right, you have like 3 phases that are part of the deal-making process. And like, depending on which stage you are in or which phase you are in, the questions are slightly different. I mean, if you look at phase 1, you need to define the partnering needs. You need to go into the partner selection. And there actually, the first questions really are, what type of partnering are we looking for? What type of agreement does make sense here? Do we want, a further question would be, do we want to keep control, or how strong should we control the partnership? Are we okay with having it hands off? Is it because we want to access a market where we don't have any affiliates or have any connections to already, right? Is it even possible to enter into a specific type of agreement with a partner? For instance, co-marketing, the slide you just showed here. Co-marketing is not a possibility in all countries. Some countries actually prohibit co-marketing for various reasons. Japan, for instance, no, not Japan, I'm sorry, China, for instance, has or follows the principle of one registration, one manufacturing site, one brand. So I think really it heavily depends, right? And also when you look at licensing agreements, for instance, when you have a licensing agreement and you want to partner with a third party, the question is, can we actually license out or sub-license or enter into an agreement with a distributor without the licensor's consent? Do we need the licensor's consent? Is there something like a sweeper clause in the agreement that would extend the obligations to the third party as well that we need to be aware of? Are there any specific royalty or milestone payments and obligations that actually are at hand? So those are somehow a lot of questions that you need to, from a legal perspective, mostly need to kind of address before you even enter into a partnership discussion with someone. And in addition to that, you basically also, of course, you need to do your due diligence on the company or the partner. What type of business profile does the partner have, right? Is it governmentally owned, such as universities, for instance? Is it a small company? Where is it located? What type of capabilities does the company have? How many employees? What's the field force? What type of facilities have they? Are they GMP compliant? Do they have the relevant industry and technical experience? And then more important, but always important, but more important nowadays, even more than in the past, what type of reputation does the partner have? Is the partner known to breach promotional activities on a regular basis by doing very aggressive promotion? As you might know, or as you probably know, the pharmaceutical products are subject to very rigorous and have a lot of limitations on how to actually promote a product, right? We cannot simply sell the product the way we could sell a TV or a car. We really have to follow very, very limited ways of doing that. For instance, we were looking into entering into an agreement, a promotion agreement with a partner in China once, and that partner actually caused a lot of concerns because they were known as being very aggressively promoting in the market in China. And one of the major problems we have when we enter into these type of agreements, right, we remain ultimately responsible towards the authorities because we still keep the so-called marketing authorization that allows us to commercialize the product in the market. In most of the cases, we enter into partnership agreements. So if we enter into a promotional agreement with the party, distribution and promotion or exclusive promotion, we still keep the responsibility towards the authorities. So a partner who breaches promotional kind of regulatory settings also kind of causes problems for us because ultimately we will be fined as well. So this is something that you always need to consider, right? And then, of course, as a lawyer, you need to think of what type of risk is it? Is it like a no-go risk so that we say we can't enter into an agreement with that partner? Or is it something that we can actually address in the agreements, right? You have a lot of possibilities to address your concerns in the agreement, but you just need to do your due diligence heavily first. And also, like, if you look into more like broader questions that also kind of come from a reputational point that more or less need to be addressed across all type of contracts, you often have like antitrust consideration to undertake. Because as you might know, right, not all partnerships are actually okay from an antitrust perspective. So the question is, are the parties potential competitors? What is the purpose of the collaboration? And could I, and that's the major question often for us, could I achieve the same result without collaborating? Because if that's a yes, then probably you should reconsider whether you actually want to enter into collaboration with a third party or not. And then clearly, coming to phase 2 now of the deal structure, the negotiation and termination phase. Here, I think you focus more because you already have thought ideally through what you want to achieve and have done your due diligence. You more kind of mostly are focusing now on the key points that need to go in this agreement to basically address the problems that you might have discovered or the potential issues that you might have discovered in the due diligence, right? One major point is always the control question. And of course, that is driving a lot of questions as well, the financial questions. But if you look, for instance, at in-licensing agreements, right? In an in-licensing agreement, you'll focus mostly in the beginning, at least, on the IP related questions. Because here it is key that you don't miss out on something, because that could potentially cause you a lot of pain and also money. You need to ensure that you somehow have the freedom to operate, which is something that is not so easily done, because in particular you have, like, when you're dealing with a university, often they have an interest in not necessarily in commercializing the product clearly, but they want to do further internal research and development and then publish. So they need to retain certain power over the IP. Whereas on the other hand, often universities also have already existing relationships with third parties that you need to focus on, whether you need to ensure that in a rep and warranty you do not end up in paying more royalties because you're not aware of such a third party, existing third party collaboration. We actually have or are facing one of these issues still since more than 2 years now. When Novartis acquired AAA and AAA then acquired Endocyte, or Novartis acquired Endocyte, we actually realized at some stage that there is an IP there is a potential IP third party that is claiming an IP to one of the compounds that was actually under development. And so we end up fighting in court since the acquisition, basically. And that's not a unique case. That happens quite a lot, right? That you buy something or purchase or in-license something, and then it turns out that you need to focus, instead of developing something, you need to also focus on a litigation. So this is something that happens, unfortunately, on a regular basis. But a careful due diligence can help you with that, and clearly addressing the questions in the proper manner in an agreement also will be super helpful. So I think that's basically it for now.
Many thanks, Martin. You brilliantly introduced the next speaker by going into the disputes that unfortunately also happen. I learned very early in my career when I joined a very large multinational that disputes and claims are part of business, and that it's just a question of how you deal with it that is important, but you have to plan and you have to be aware that it's going to happen. It's unavoidable. So I'm looking forward to hearing Claudia Goetz-Stehlin, who is going to tell us about her expertise in the field. She is currently a partner at Kellerhals-Carrard in Basel, Switzerland, but formerly she was for many years head of litigation at Novartis, and she gathered altogether around 20 years in litigation and arbitration, as you cannot see when you see her. But she combines now dispute resolution expertise with many years in the significant healthcare and also life science processes. She is now listed also as the next generation partner in the field of healthcare and life sciences by Legal 500, and advises and represents pharmaceutical and medical device companies in all areas of healthcare and pharmaceutical law. Claudia, I also have a few questions for you. What are the typical causes of dispute for healthcare and life science companies, and to what extent are such disputes suitable for arbitration?
Thanks very much, Caroline, and good afternoon, everyone. So it remains for me to elaborate a bit on what happens if the deals go wrong. The many deals, the many agreements that we just heard about from my colleagues. So, Caroline, you asked.
Claudia, I'm sorry to interrupt you. I hear some noise. Could you maybe move your mic? Because I didn't hear this noise when we prepared before the conference. Can you just check your mic?
Is it better now?
No, it's making some following up noise.
Okay, let's try again.
Now it's perfect. Perfect. You can go on. Sorry for the interruption.
No worries at all. So just tell me if it's going bad again. So you ask what are typical causes of disputes for healthcare and life sciences companies, and to what extent are such disputes suitable for arbitration? So I think, there is not a specific life sciences fact pattern, but I think broadly speaking, one can say there are a couple of typical types of life sciences disputes, and I would leave here aside investor states disputes. And I think if you look at these types of disputes, it becomes very clear why they are very suitable for arbitration in particular. So I think the first group is really commercial disputes. Commercial disputes, and I mean here disputes relating to all the different collaboration agreements covering the different stages of a product's research, development, production, and marketing. So exactly what was just described by my colleagues. And out of these different collaborations, typically disputes can arise. And, often these collaboration agreements, they include some kind of endeavors or efforts obligations, such, for example, the obligation of one party to use best efforts, to use commercially reasonable efforts, for example, in a co-marketing or in a co-promotion agreement, to co-promote or to co-market a specific product. And disputes typically, in my experience, arise out of such agreements. And what is very typical in these disputes is that the parties have an ongoing relationship. And what is also typical in this dispute is that they are multi-jurisdictional, so they are truly international. Then a second group of disputes are, in my view, disputes related to international licenses agreement, in-house or out licenses agreements, as patents and know-how are of primary importance in this field. Typically in these disputes is that they involve highly sensitive information, such as IP, and also often are really very in close interaction with regulatory issues. Also, the amount at stake is normally very high in these disputes. A third bucket, I would say, is disputes related to M&A activities, because from what we have heard, and I relate here in particular to what Martin said, many disputes arise out of M&A activities, because the life sciences industry is very active in that field as well. And so you see disputes that relate to liability or warranty claims. And here also the amount at stake are quite high normally. And then a fourth category that I've seen are insurance arbitrations arising out of US mass tort litigations, where the issue was whether the product liability cost fell into an insurance agreement. Because, you know, product liability claim is typically also something with which pharmaceutical company are confronted. So all of these disputes have the following in common. They often involve very high value, particularly when the dispute relates to lost revenues or from lost royalties or lost sales. They often or most often involve more than one jurisdiction, and if the party had to litigate in different state courts, that would be an issue. So arbitration really allows them to resolve the dispute in one single neutral forum. And, you know, I don't have to say more about the enforcement, but it's also clear that the enforcement is much easier under the New York Convention, where you can enforce awards easily. Then, and this is really important, they are technically complex because they concern IP and regulatory rights, typically question related to good manufacturing compliance and the like. State courts likely would be overwhelmed by such disputes. And, you know, it is therefore very important that life sciences companies have the right arbitrators who look at these disputes, which is also a feature of these disputes. Then I think what is sometimes underestimated in these disputes is that almost always the correspondence is in English. And, you know, in many state courts, you would at least have to translate the most important documents, which is really an advantage of arbitration. So overall, the flexibility that arbitration provides is something which speaks for arbitration. Then they involve highly sensitive topics, including trade secrets and reputational aspects. Martin was relating to that in his presentation when he talked about promotion, and pharma companies are acting under the public glare anyways, so they normally do not want to have more attention, even if the dispute is civil in nature. Arbitration is therefore in generally better suited for these disputes than state court litigation. And importantly, I already was referring to that, the parties have an ongoing relationship between each other. So arbitration, often combined with pre-mediation, is something which serves them well.
Many thanks, Claudia. Is there any very specific issue and challenge that you see the life science and healthcare companies face during an arbitration? And are there very specific aspects that are unique, completely unique to this sector?
Yes, I think there are, and I think it already became clear when you were listening to my colleagues. Starting with Alexandra already, and then obviously Daniel as well. It's clear that these disputes, from my experience also, they concern highly technical and scientific information. And, it's really a challenge in my experience to make those issues accessible to the tribunal, even to own counsel. It's often difficult to understand these issues. And I remember myself one very high-stake case, an arbitration that I led, where we finally brought the whole testing equipment to the tribunal, to the hearing room, because after several days of hearing, we just were not convinced that the tribunal understood the issues. They tried hard, but we had our doubts. So this is really an issue, making sure that the tribunal understands the issue, that you have the right experts, that you have them early on, so that your own counsel understands the issues. I think that's also, to add that, I think it's important that you have good in-house counsel who really drive the arbitration together with outside counsel, who is involved in order to make sure that these highly complex topics can be made accessible to the tribunal. Then, as I said, there is an ongoing relationship between the parties. That's specific, in my view, in these cases. Often you have the situation that the parties are, for example, in dispute, let's say, with regard to a co-marketing agreement, and in another part of the company they are working together on testing a substance. So that gives rise to very difficult question, and there you are also served with a dispute resolution mechanisms that gives you a lot of flexibility. Sometimes in this situation, mediation can be something to test. So that is just something to have in mind as well. Then I also already said, confidentiality is a topic. As highly sensitive, protected information is often involved. That is something to consider early in the process. And then I mentioned the connection to regulatory and IP topics and market realities. That you have to have.
Claudia,
yeah.
I'm sorry to interrupt. Your mic is again doing some noise.
Something. Okay, I conclude.
What you did before worked, so you do it again.
Is it better now?
It looks better, yes.
Okay. Then you have to have market reality that play an important role. You have to have experts. You have to have counsel and arbitrator who are able to understand what, for example, means that a party needs to apply commercially reasonable efforts in detailing a product to healthcare professionals in a certain agreement, and that needs experienced players involved. That, I would say, are the most important challenges that we face in these disputes.
Thank you very much. I have a last question before you can then turn to the chat. But first, what would you say are the typical challenges before and during an arbitration proceedings? Do you have any tips that you would like to give to companies with respect to the handling of the arbitration procedure?
Yes, so I think, in my view, and I do litigation and arbitration, but I really think by choosing arbitration for these highly complex processes, I think that's already a good choice. A good choice, because you really then have the flexibility that you want to have, and I think also that you have to have experts very early on involved in the process, You have to choose the right counsel and the right arbitrator. That's important in every arbitration. But I do think that in these cases, it's particularly important for the reasons just mentioned. The other thing is that I think it's important to have in-house counsel involved in this arbitration, because you need to have people who can advise. You can advise on the highly complex technical questions, and who can advise swiftly and can make sure that you are a step ahead of your counterparty. Thanks.
Many thanks, Claudia. This was very clear, I trust. Now I will ask all the panelists to come back with their mics and cameras so that we can have a discussion together and answer some of the questions that were made in the chat. Hello, Martin. Hello, Danielle.
Hey.
Still missing Alexandra?
Yes, I'm sorry, my camera doesn't work. My video doesn't work, so you will only see my picture.
Well, that's a pity, but at least we will hear you. That's good. So, Alexandra, since you were the first one speaking, and you spoke about the first part also of the life cycle of the industry, was there any question in the chat that you would like to address now for everybody's sake orally?
Yes, I think there are two questions. One is a purely technical question about the clinical phase. So to get a product on the market, there are usually 3 phases, but not all drugs go through the same path, clinical path. For very rare disease, which have high consequences on life of people, you can have situation where you will have only 2 phases, and the second one will be what we call a pivotal phase, which will allow for the product to get on the market before phase 3. But most of the time, the products go through 3 phases. There is also something that is called a phase 4 clinical trial that is after marketing authorization. That means the product is already sold on the market. And you can have this required by the regulatory authority. They want to control the safety of the product, so they want a further clinical phase. Or also, you can have this if, as the owner of the product, you would like to expand the applications of your product to new disease, so you might have an additional clinical trial. And another case, which happens sometimes, is if you want to use your product and you want to make sure that there are no interactions with other medications, so you will make a phase 4. And there can be other situations if you want to combine your product with another product that already exists, then that would also be considered phase 4. And then the second point that is very important to me is the question about, is it necessary to patent an innovation? In the life science business, if you want to bring something on the market, because of the costs, you have to base that on a protection, which is a very strong protection. And I mean by that, the patent. It doesn't mean that know-how is not a good protection, but know-how involves secret, or you can, and you cannot have secret for drugs. You have to disclose all the products you use. You have to disclose the recipe of your drug. If you take the example of the Coca-Cola recipe, that's one of the most known example of a know-how that has been used and protected for a lot of years, and that is highly valuable. But for drugs, since you have to disclose the recipe, you cannot protect your drug with know-how. You cannot keep it secret. And the only protection that will be strong enough during the life cycle of your product is the patents. So yes, if you want to bring a new drug on the market, you need one or more patents. Usually you have one patent which covers the molecule or the compound, and then you will have application patents or use patents. And you can also have patents on the manufacturing. So if you don't have any patent, you will not bring a drug on the market. That's for now.
Many thanks, Alexandra.
Can I briefly add something to that? I think, and that's mostly for like, yes, before you even have the patent, so what you need for the patent. But when you come to the market or when you go to a license at a later stage where you already have an existing patent, you'd also define and use know-how for various things, right? That's not the know-how related necessarily then to what is actually in the patent application and what is used for that, but that is like indirectly related to it. For instance, like some journals, notebooks, lab notebooks, some further information like discussions around improvements, etc., that do not end up in a patent application. Manufacturing know-how, so there's know-how that is like very broad, and that will be defined in most agreements as well, because it is an important key. The longer the product lives, the more important also this know-how gets in relation to it when you want to enter into a partnership or so with someone.
Oh, thank you, Martin. I think there is also a lot of know-how in this chat today. Daniel, would you like to add something?
Yeah, maybe I'll pick sort of the ethical, moral, and maybe a little bit more controversial point, because I think it's interesting. Also, maybe a little bit in the defense of the industry, or at least to show the complexity of the questions that we have. Someone pointed out, actually rightfully so, I think it's a very good point, with all the government funding, what about the transparency and the profit taking and the impact this may have on these vaccines? I think it's a very strong point, and I think it's one that needs to be touched on. I mean, my observation is, most companies, including ours, actually, we have said, and we have said that we definitely took that a lot to consideration. But that does not mean, when I said that a lot of the risk was shifted to governments, let's keep in mind that a lot of the risk remains with the companies that are doing this. So, for example, in our case, one production line that is manufacturing 100 million doses a year was funded by us, with entirely the risk with us, if the product was to fail. So I think companies have stepped up largely, but there are interesting moral questions that go beyond that. You focus on pandemic, but we're also manufacturing cancer drugs. How much space that is currently used for your cancer treatments are you morally or ethically allowed to give to COVID vaccine, for example? So it does cause a lot of interesting questions for the pharma companies, where it's difficult to find the right answer, and the answers are always going to be controversial. There will always be someone who will disagree with the answer that you thought was right. And when we talk about government funding, I think another very controversial item is going to be which government. So some governments have stepped up. There was a lot of some of the governments haven't, even though they could afford it, and there has been amazingly embarrassing, I think, infighting between governments, with borders closed, and players like us having to navigate them. When masks are being blocked at the border, that you need to manufacture drugs because another country wants to keep the mask with them. These are problems. These are actually real life problems that the industry is facing. So a lot of good things with this pandemic have popped up, and a lot of less good things have been observed as well.
Well, such is life. Unfortunately, there are good people and less good people, and good behavior and less good behavior, triggered by any circumstance. Claudia, you seem to be willing to share some thoughts.
Yeah, I mean, I agree with that. I mean, but we could probably talk about this the whole afternoon. I mean, I don't have to say anything to that, but I agree with what Daniel said.
Is there any plan, maybe, Daniel, what will you do when we are all vaccinated? What will you do with all these factories and the product lines?
Well, I think, looking forward, I mean, that's me as a lawyer who doesn't really, who gets it wrong most of the time. But I think what has been observed, with the vaccine is mRNA is there to stay. So this is a technology that we haven't seen before, really, operating. Now we have 2 vaccines that have been approved. One other will eventually be as well. And it's a technology to stay. And it's a technology that will not only allow very quick developments of vaccines for completely different applications, that's what we have seen now, but it will also go in areas like cancer treatments. And this is, I predict, with probably the wrong angle as a non-scientist, but I predict that we will be using this technology, this equipment that we have bought will still be used for many other applications in the future.
Many thanks. What do you think, Martin?
I was on mute. No, I mean, for me, it's yeah. I briefly went through the messages again because I somehow missed most of these ethical questions. So no, for me, it's actually very interesting when I went through it. There are like very interesting comments in there, and one of them actually jumped on me right now. It's like new and patented does not necessarily address an unmet need, and maybe often more effective than what precedes it or so. So new does not equal innovative. And that's a very good and interesting point. But what I have seen over the last decade, at least, is that often, while I agree that not necessarily everything that is new is considered to be like innovative in the broadest sense. Not like, for instance, this new type of vaccine and or kind of, if you look at radioligand therapies, what we are dealing with, right, where we do have a true innovation because it uses a totally different type of compound, which is radioactive, and it's totally different with new challenges. But I feel when I look at it, often nowadays, news still means, because otherwise you cannot survive with the drug on the market. New means at least that it has shown in some trials that it has, at least compared to another drug that is already existing in the market, somehow an advantage. Overall kind of quality of life is better. The drug has shown improvement on efficacy, etc. So new, at least in my perspective and in my experience, means nowadays that it actually helps someone who kind of has been on a different drug before. If it's not like fully innovative and an entirely new therapy, which I think we refer to as innovative, it at least is there to help. Otherwise, the drug doesn't survive, because when you look in the cardiovascular field, right, often you have like patients that have been living with the heart failure over years, and heart failure is a kind of chronic disease that slowly decreases your life. And even if you have been on very stable term kind of condition due to some drugs, it still has shown that there are drugs that have been brought to the market with, like, interestingly, 2 old existing compounds, right? But together they work much better. So there is type of an innovation in it, and that this new drug actually has shown that it is more efficient and effective, and even like not unsafer than before, and those patients actually have an improvement in the quality of life. So I think nowadays, because otherwise it's not worthwhile the efforts and you cannot survive in the market, at least means that somebody has an advantage from it. And that's not necessarily just the company, but also the patients, because it really helps them improve the life quality, which is something that is more important than ever, I feel.
Many thanks, Martin. Alexandra, we're glad to have you back. Is there anything you would like to add? Or maybe Claudia, did you see anything in the chat that you would like to add?
You know, there were a couple of questions related to selection of arbitrator and whether they should have a scientific background, and you know, also what's the role of expert. I think, you know, it cannot be overstressed that the role of expert is extremely important in these type of disputes. And what I think should be stressed is that they should be really early on involved, that the selection is important. In some fields, there are only a very few in the world. And so it's really the strategic planning is important, and the engagement of the in-house lawyers in the companies. You cannot delegate these type of things just to your outside counsel. And it's fun to do these cases. So that's just the thing I would say here. Then selection on arbitrator, I already said that. You know, I don't think that they necessarily need to have a scientific background, but I think they need to have, in my view, some kind of industry experience. But even then, you know, every case they are not scientists. You still have to, you know, it really have to invest in the technique to make these things understandable to your tribunal. Otherwise, you just risk of losing your tribunal, losing that they don't understand the issues.
Thank you, Claudia. There is a direct question to you that just appeared on the chat. Is it advisable to bring in-house counsel as witnesses?
I don't know. Can you repeat? Is it advisable to bring in-house counsel?
As witness.
As witness? It depends. I had cases where that was necessary. You know, when they were witnesses. It depends. If they are a good witness, that can be the case. Yes, I had good in-house counsel as witnesses, excellent ones. I remember one very good one.
Yeah, I must say, I think that when I was in-house counsel, I was amazed to see the level of expertise that is in in-house counsel, and today is no surprise the same. A few participants are asking whether there is any reading material or sources that you would recommend. I guess it's not really easy to recommend orally like this, but maybe if you give me a few sources that you think are good in English, if you have any, I'll try. Maybe I'll make a LinkedIn post if you have any sources you could cite. I could make a LinkedIn post for the participants. There is another question that is very technical, so I don't know if one of you can pick it, but to manufacture a vaccine, do we need an information of R&D or optimized viral vector itself? I confess I don't understand the question, so I'll say it again. To manufacture vaccine, do we need an information of R&D or optimized viral vector itself?
It's one for Martin, I believe.
Yeah, or maybe for Danielle. Maybe I can give a beginning of answer. For most of vaccines, you need a viral vector because you need a vehicle to bring the vaccine into the cell, so into the body. But I don't know what information of R&D means. So I think maybe the person who asked the question could be more specific. But the answer with respect to viral vector is yes, most vaccines need viral vectors.
Okay. I see. Maybe
so, and is there a specific, I think,
said, you would need the RNA.
If I read that, is there a specific know-how on how to breed the viral vector required?
Okay, so maybe we'll.
So the question, I think, but because the question I think is in the end whether that know-how to breed this specific viral vector actually is required to be able to produce the viral vector in greater quantities. But to be frank, vaccines are not my area of expertise, so I do not know how to operate them.
Okay, so I guess that this will be a technical question to be asked.
One of the privileges of being a lawyer, you don't need to mess too much about
yeah, if I actually would be able to probably answer this question, I wouldn't be a lawyer.
I must say that I remember being an in-house counsel is a true lesson of humility as to what knowledge we have. Because as soon as we talk with colleagues at the cafeteria, when we were allowed to do that, you would see the limits of your knowledge. You would also see the limits of their knowledge. But that made you humble to know that you only have a small expertise in a small area when you have one, and that others have other perspectives. I think we have answered a good number of questions. If one of the students would really want his question to be answered now, maybe he can put it again so that we see it at the top of the questions list. So there is one, can one develop a vaccine for non-infectious diseases?
I think the answer is yes, but I'm not sure.
Yes, there are projects of vaccines in immunotherapy for cancer. So you have now different projects that are currently, and some of them are in clinical trials for vaccines for cancer. So yes, I guess the answer is yes.
Oh, thank you, Alexandra. Okay, I must confess that I have reached the limits of my knowledge when I read these questions that are asked.
I think the question, can a license agreement for vectors be treated as a sales agreement if it contemplates a conditional sale of cell lines in the future?
Martin, before you answer to that question, I guess that's one of the questions that the students have to answer in the Vis Moot.
Ah! So I don't know. I don't know the answer. Sorry.
Yeah. In any event, I think this is getting too technical, and also we are entering dangerous grounds. We do not want to give advantage and to give neither the right answer nor the wrong answer to the students for the Vis Moot. I do thank you all, my dear panelists, for the presentations you've made, and also for the answers you have prepared and answered, and also to the participants for your active participation. It was very nice to have, at some point, I think we had almost 200 participants. If you missed a part of this presentation, or if you want to see it again, you can look at the video recording that we're going to put on our website under video gallery. That's also where you can see the webinar of last week about the joinder of parties, which was very interesting, I think, for participants to the Vis Moot. And I look forward to seeing a lot of participants as well to the next webinars and to the Vis Moot, the pre-moot that SCAI will organize on the 6th of March for those teams that have been selected. I wish you all a lot of luck a lot of fun. You are learning a lot right now when you're preparing the Vis Moot. The key and the target is to learn. Some will win, but you will actually all win by learning. And just for your information, you will also make friends. You will make friends that will remain with you forever. And I have one of them today on the panel. And this is what it is all about, developing not only your knowledge, but also your network and your friendships that will accompany you throughout your life, your private and your professional life. And I wish all of you, and also to my co-panelists, a lot of fun in the future. And I hope to see you again live at some point, and not in our offices or in our homes or chalet for those fortunate ones. I wish you all a great end of the day, and hope to see you again very soon. Bye-bye.
Thank you.
Bye, Helen. Bye, everyone.
Bye.
How do I leave?